And now here's your host, Ken Swarner. And we're going to be discussing lawsuits that involve the United States military. And certainly a leading topic in that discussion right now is sexual assault. And I have Mike here today to help us navigate questions regarding that topic and helping you out there decide if this is something you want to proceed with and see about getting some help. And Mike, thanks for joining us today.
Thanks for having me, Ken.
So sexual assault is prevalent in the military. Can you bring us up to speed on what rights military members, family members, and DoD employees have currently when they are the victim of abuse by someone else within the military system?
Sure. Well, anyone, even military members, can bring claims against individual perpetrators, and even potentially individuals within their chain of command for sexual assault that occurs in the military. But not everyone is eligible to bring claims against the military itself. Unfortunately, those victimized while in the military, whether on active duty or in the National Guard or reserves, are ineligible to bring claims for sexual abuse against the military because of the Supreme Court's ruling in a 1950s case that bars service members from bringing claims against the military. It's called the Ferris Doctrine. However, any civilian that was sexually assaulted by a military member, whether it's a spouse, a child, a retiree, civilian contractor, or the like, has the right to bring a claim against the government, and they are not barred by the Ferris Doctrine.
Oh, interesting. And so what, so that we get a sense of where it's at right now, but what's possible in the future? I mean, is this something people have to give up on totally, or could these things change?
Yeah, and so several things are possible in the future. First, the Supreme Court could overrule its ruling in Ferris versus United States. Justice Thomas has in the past been very critical of the continued use of the Ferris Doctrine, as has other Supreme Court justices, like Ruth Bader Ginsburg was in her time, so was Justice Scalia. Justice Scalia actually once wrote that we can think of no other judicially created doctrine which has been criticized so stridently by so many jurists for so long as the Ferris Doctrine. And so there's definitely been, in the past at least, some pushback by the Supreme Court and some willingness to revisit it. However, recent petitions to the Supreme Court to address the issue have been rejected, signaling that the court's reluctant to revisit the issue at this time. And so that's the first thing that could happen. Next, Congress could act by passing legislation that allows service members to recover against the government for injuries incurred while in the service, including sexual assault. There's been bills proposed in the past that never made it out of committee, never got full support. The National Defense Act that was passed recently that allowed service members to bring medical malpractice claims administratively within the military system at first had sexual assault as a claim that could be brought, but before the act was actually passed, those provisions were removed, so sexual assault wasn't included. And so Congress could act expressly to allow service members, and then there could be, in a future National Defense Act, a provision that allowed sexual assault claims to be processed administratively within the military itself. So those are various things that could happen, and there's various groups that are actually actively lobbying for these types of changes. And so there's definitely a movement and a climate for these changes to occur. Whether they do, it's still a wait and see with that.
Yeah. So, but it is possible, right? Because hasn't there been recent or relatively recent changes within like medical malpractice?
Yeah, and so in the National Defense Act, they included a provision that allowed service members to essentially bring claims administratively within the military. They can't bring them in federal court or in state courts, but to bring claims for medical malpractice with strict provisions. And so, there's a 2-year statute of limitations on it. There's these injuries couldn't have occurred in a combat zone. There's other qualifications, but that was passed, and it's only a temporary window open for medical malpractice claims in the military. However, with the Biden administration, we could see this get extended. We could see this get revamped. And so there certainly seems to be at least a willingness to look at allowing service members who are injured while in the service to be financially compensated for these injuries. And so, we could see a similar result with sexual assault in the military moving forward, but that's right now it's speculative.
Sure. Okay. Well, before we get into some questions about the process when someone comes forward and works with a law firm, you have some military experience, isn't that right? Could you give us a little background on you?
Sure. Yeah. So my military background, I joined the Army when I was 20 years old, active duty, and I was in the Army for about 9 years on active duty, and I was a combat engineer. I deployed to Iraq twice. I, was in line units my entire time in the military, and in 2013, I medically discharged from the military, and so I have some relative experience with the military, not in a sexual assault capacity, but I, I am familiar with how the culture, climate, and the like operate within the military.
Yeah. And so then what happened after the military? Obviously, I think you became an attorney, right? You did that somehow.
Yeah. So when I got out of the military in 2013, I went to Washington State University and attained a business degree, and then immediately after that, I went to the University of Washington Law School and received my judicial doctorate, becoming an attorney, and I've worked here at Falcock and Retitus Amalia ever since.
Oh. And tell me a little bit about your firm.
Yeah, our firm we handle a lot of complex civil litigation, from wrongful death, catastrophic injury, and one of our specialties is representing sexual abuse survivors. And so we've had hundreds and hundreds of sex abuse survivor clients. We've litigated these issues over and over again. We're very good at this kind of law. So we have a tremendous amount of experience dealing with these issues and prosecuting them to their fullest extent to get the best possible outcome for our clients.
So obviously your experience in the military, your firm's experience with things like sexual assault. When someone comes forward from the military world, typically, what are those fears people are going to have? I would assume being in uniform and then turning around and possibly bringing suit against your employer probably comes with some pretty big anxieties, especially for someone in the military, right?
Yeah, absolutely. I mean, when we're talking about potential pitfalls for coming forward with your story of being sexually abused in the military, I'm not gonna sugarcoat it for you. There are several pitfalls that could happen, and negative externalities that can occur. While I'll preface this with saying that I encourage anybody who was sexually assaulted in the military to come forward, I do want to be candid and let you know what could happen and what a lot of times does happen to service members that do come forward. And so first, you could be ostracized by your unit, where people start to, see you as a troublemaker, as someone who is, making up claims. You could be seen and the rumor mill starts to circulate that, you either wanted it was consensual, or that, you are promiscuous. So those are the first things that could happen, is that you get ostracized. Next, it has the capacity to affect your ability to advance in your career, because once you make waves, again, you're kind of seen as a troublemaker, as someone who doesn't go along to get along, and so there can be negative ramifications for your career. You could also be moved from your unit, and rather than them removing the perpetrator, and they could move you to a different unit and potentially to a different base in a different state or a different country, because they don't want to keep the perpetrator or the victim in the same unit or in the same base. And sometimes it's the victim who they'll move and not the perpetrator. And then on top of that, if you report sexual abuse in the military, there's a high likelihood that they're going to require you to retell your side of the story, not just once, probably over and over and over again to various different levels of people within the adjudication process. And so, the effects of having to retell what happened to you and defend what happened to you it's very traumatic. And so those are some of the things that can happen when you come forward. And I just want to put those out there so that, you're aware of it if you're in that situation. However, I encourage anybody who is a victim of sexual assault in the military to come forward. And the reason for that is that many times, we all know that sexual assault in the military is vastly underreported because the service members themselves know about these pitfalls and the negative ramifications that can happen when they come forward. Oftentimes, you don't get the help that you need. You're not believed. The perpetrator is not punished. But when you do come forward, what often happens is you give strength to a lot of other victims who didn't come forward. They hear your story and they think to themselves, me too, that happened to me. And there's a healing quality to that. They feel empowered by your bravery to come forward. And we see this, within the Me Too movement all the time. Take Harvey Weinstein, for example. When the first accuser came out, once that first trailblazer made the accusations, then another came, and then another, and then another, and then another. And it's a cascading effect because all of the victims behind that first trailblazer who brought out their accusations become empowered by that. And so they come too. We saw this not with just Harvey Weinstein. You saw this with Bill Clinton. You saw this with Donald Trump. You saw this with Brett Kavanaugh. You saw this even with Deshaun Watson, which is going on right now. And so by being that trailblazer and having the courage to come forward and tell your story and face those potential pitfalls and negative ramifications that could befall you by telling your story, the result oftentimes is you were empowering so many other people behind you, and you're helping them heal, you're helping them gain strength, and you're helping them to reach the decision themselves to come forward. And so, that's why I always encourage, if it's an individual decision that people have to make, and if you decide not to come forward, I understand, but I would encourage anybody to shine light on this issue, because the more light that's shined on it, the better chance we have of reaching a place where we can start to mitigate this epidemic of sexual assault in the military.
Yeah, so I would imagine that working with a law firm that has a lot of experience in that also means you folks must have, just a lot of experience helping victims with the other things, for getting them prepared, for knowing what's going to happen, but also to not feel shamed and not feel ashamed of what happened, and also maybe resources. And could you speak a little bit to that?
Yeah, absolutely. When a victim calls our office and wants to explore their potential legal options for having been sexual assaulted, we understand how difficult those conversations can be. And so one of the things we try to do is we try to have those conversations. We try to gather the information that we need so that we can evaluate essentially their legal options without prying and without requiring them to, relive the trauma or to divulge specific details in this initial consultation and whatnot. And so whenever somebody calls our office as a sex abuse survivor, whether it's in the military capacity or as a civilian unrelated to the military, consultation is always free. And we will sit down with them and we'll have that conversation with them with care and with compassion. Um, and we will advise them of what their legal options are. A lot of times we're in a position where we can perhaps help them further by representing them. And other times we can't. It's a case by case determination. But even in the situations where we can't represent them, maybe the fairest doctrine is barring their suit or what have you. We will advise them of their legal options. We will advise them of resources that are available to them to help them heal and to get to a place where they can pick their life back up and move forward, because oftentimes one of the things that we're well aware of is sex abuse shatters people's lives. It just breaks everything apart. And after the fact, the victim is often left having to pick up the pieces of their life and trying to figure out how to move forward after these events. And we do the best that we can to try to direct them to the resources that they need to be able to do that. And we're always willing to listen and to talk and to go over these options with them so that they can be as informed as possible so that they can move forward.
Yeah, that's excellent. Tell me a little bit about how does judgments work in terms of pay with a law firm? I mean, what would someone expect if they were to win their case or lose their case? Either way.
Yeah, certainly. And so when we take a client on for a sexual assault claim, we do it on a contingency basis, which means that the client doesn't have to pay anything up front and doesn't pay anything at all unless they win the case. And so even if they lose their case, it costs them nothing. We take a percentage in the event that they win, and we recover some monetary award for them. And so that's the only time that we get anything, or that's how we would get paid essentially if we represent a client for a sex abuse allegation, is if and when they win. Otherwise, it's completely free. And our law firm is a high-powered law firm that has a lot of resources behind us. And so when we take a case, we prosecute it to the fullest extent with experts. We go at it with the mentality of trying to achieve a decisive victory. For lack of a better phrase, we will step on the neck of the defendant, the other side, and prosecute the case to the fullest extent to get the victory that we want. And that's how we approach these cases.
Yeah, and so right now, some people, as we've talked about, are barred from being able to seek justice. Is there value in giving their contacting you now anyway, maybe to get on a list for if things change and they can work with you? I mean, would you want to hear from people, even if right now that doctrine is preventing them from bringing suit?
Absolutely. There's many benefits to that. If a survivor were to contact us and share their story with us, like I said, we would go over their legal options with them. And perhaps they wouldn't be able to bring a suit against the government for whatever reasons that, depending on the particulars of their situation. But there is a possibility that their testimony could aid in the crafting of a legislative bill that would be pushed forward, or that their story could help other survivors, or that in the future, if a law was changed or the situation were changed, we would be able to contact them and let them know, okay, now you can bring your claim and we're ready to move forward with you if you are. And so absolutely, even now, if a service member or a civilian was sexually assaulted and they want to understand better where they sit as far as their legal options, we encourage them to call us whenever they feel ready. And we would talk to them, obviously, free consultation, and explore their options with them.
Great. Well, thank you. I really appreciate that. I think that's really helpful information for folks. And I know we'll be checking in again in the future with other questions related to this topic. Mike, I really appreciate it. Thank you for your time.
Hey, thank you, Ken.